Welcome to UK Visa and Immigration channel. Please subscribe to our channel for more latest and useful videos. Business Immigration, a guide for employers. Introduction. The UK's immigration system underwent significant change as a result of Brexit and the end of freedom of movement for European nationals on December 31, 2020. UK employers wanting to recruit migrant workers need to understand the new immigration regime and, in particular, how the changes affect the recruitment and employment of EU nationals. At present, there are two main business immigration routes enabling overseas nationals to work in the UK: the EU settlement scheme and the points-based system. In this guide, we address the key issues for employers to consider under these routes. The UK's immigration system. With effect from January 1, 2021, everyone, except for UK and Ireland nationals, requires immigration permission if they want to work in the UK. The majority of overseas nationals wanting to work in the UK will gain immigration permission through either the EU settlement scheme, available to nationals from the EEA and Switzerland, referred to as EU nationals in this guide, who were in the UK before 11 p.m. on December 31, 2020 and certain of their family members, or the points-based system. The EU Settlement Scheme, EUSS. Following the end of freedom of movement between the UK and EU member states, any EU nationals who arrived in the UK before 11 p.m. on December 31, 2020 will need to apply for settled status under the EUSS in order to retain the right to live and work in the UK. Applications must be made by June 30, 2021, otherwise the person will no longer have the right to work in the UK without obtaining alternative immigration permission. Employers may be faced with challenging decisions if they employ any EU nationals who have failed to apply, or have made an unsuccessful application, to the EUSS before the June 30, 2021 deadline. You may want to take advice on the steps you can take now to minimize this risk, including how to encourage EU employees to apply under the scheme. Family members of EU nationals living in the UK before the December 31, 2020 deadline may be able to apply under the EUSS. There are different rules for family members depending on their nationality, their relationship to the EU national and the date of entry into the UK. EU nationals who were not in the UK before 11 p.m. on December 31, 2020 are not eligible to apply under the EUSS and will be subject to the same rules as non-EU nationals under the PBS. The points-based system, PBS. All nationals from outside the UK and Ireland looking to work and/or study in the UK who aren't eligible to apply under the EUSS and don't have an alternative route of entry will need to obtain a visa under the PBS. The main routes include skilled worker, intended for skilled roles which are sponsored by a UK employer. Intra-company transfer, intended for overseas employees moving to a linked UK entity. Global talent, intended for leading individuals in academia/research, the arts and digital technology who have been endorsed by an official body. Startup, a route for entrepreneurs who have been endorsed to set up a business in the UK. Students are sponsored by an educational provider, but have the ability to work in the UK, subject to various restrictions. Graduate, this route will be open from July 1, 2021 for individuals who are already in the UK under a student visa and who meet various eligibility criteria. The visa allows the graduate to stay in the UK for 2 to 3 years to look for, or undertake, work. There are no restrictions on the type of work that graduates can do under this type of visa. Investor, available for high net worth individuals who provide financial investment in the UK. Innovator, a route for individuals who are experienced in business and intend to run a business in the UK. This guide focuses on the skilled worker and intra-company routes as these are the most common routes to employ overseas nationals in the UK. Skilled worker. This route is available to skilled migrants with a job offer from a UK employer which holds a sponsor license, see below. Critically, employers must only sponsor migrant workers where there is a genuine vacancy and must keep documents to show that this is the case. In order to qualify for sponsorship under the skilled worker route, the role must be in an eligible occupation, as set out in the appendix. Skilled occupations of the immigration rules offered at a minimum salary level. In most cases, this will be £25,600 or the going rate for that particular job, whichever is higher. Sufficiently skilled, at or above RQF Level 3, which is A-level qualifications or equivalent. In addition, applicants must meet minimum English language requirements and, if they are applying from outside the UK, hold a prescribed level of funds in their bank accounts, although employers can underwrite this financial requirement. There are significant costs associated with skilled worker visas, and these costs, together with the processing times of obtaining visas, need to be factored into recruitment processes. A skilled worker visa can be issued for up to a 5-year period, but provided the individual continues to meet the eligibility requirements, they can apply to extend their visa as many times as they like. This route also allows the individual to apply for indefinite leave to remain, i.e. the permanent right to live and work in the UK without restriction, after 5 years, provided various criteria have been met. Thanks for watching this video. For any further information, kindly contact us on the email mentioned on the screen. Thank you.